and I don't. I
Sure.
really before this, and I just forgot. So pick up where you were. I apologize.
No worries. So, in the retirement space, when the defined contribution kind of a world started to grow and employers started to understand that they were now providing a benefit in a different environment, they had the 408(b)(2) regs that came, and we started to get transparency around what things cost. And if you think about it, back when I started in the business and we were getting people to put dollars away into a 401k plan, the average plan was running most employees about 3.5% or 350 basis points. The average account values were about $17,000. Participation in plans were extremely low. There was about 40% participation rate. And through this proactiveness of employers really hammering home that this was a benefit, and through the transparency of the 408, fees have significantly come down. The average employee is paying, about 1/4 of a basis point or 1/4 of a percent, excuse me. And average account balance is over $100,000. So now with the CAA, to me, this is just the catalyst. This is exactly what we saw in the retirement space when transparency comes to the market and employers now start to feel the liability of us sponsoring an ERISA-based plan. Things start to change. And so to me, the CAA has done a couple of things. One, it's given access to information that employers never had before through the removal of the gag clauses. Granted, it's very difficult to remove these, and we're still getting a lot of pushback, which is why you're seeing the lawsuits, but it's a start. So removing those gag clauses, getting information where an employer can start to do a prudent process around cost and quality is super important. Compensation disclosures, that's also something new that came out with the CAA. Understanding who's working for you in what capacity and who's paying them is very important. And again, that came about in the 408(b)(2) regs in the 401k space. And we had to disclose as consultants who was paying us, how we were getting paid, the services we were providing. And now brokers are going to have to do the same thing. And this to me is super positive because the really good brokers out there will rise to the top because they've been doing this for a while. And the bad actors will quickly be, shown the door by the employers. And then there's, of course, additional reporting requirements under the CAA, which I think will also highlight where some of the challenges are in the healthcare space. So I'm excited to help employers start to establish, adhere, and document their fiduciary process. And that's really what Fiduciary in a Box is about, is helping employers who have done it on the retirement side for many years now be able to do it on the healthcare side. And we know that it's not easy. Fiduciary is not easy. It's a complex program and process. But if we provide valued partners like their consultants with the tools to be able to provide the employers with that process, we know that it will create disruption and it will create change. So we're excited about that. Hopefully that's what you wanted me to cover, Daryl.
Yes. So one of the big questions that I wanted to bring up today and get everybody's input on, and maybe you could share with us, Jamie, what's happened over those 20 years with retirement consultants, from none of them being co-fiduciaries with their clients to now a certain percent of, I know mine basically says, yeah, that's a part of the package I give you. I'm a co-fiduciary with you on your retirement package. Where do we see the future of benefit consultants becoming co-fiduciaries with their clients as they're helping to design and manage their health plans? And then I want to open that up and get thoughts from Darren and Chris, if you've got ideas or any of the consultants to say, is this in the future? And should we be maybe promoting this as a way to differentiate consultants? So just your thoughts, Jamie.
So it is interesting because, again, in the financial industry regarding retirement programs, when I first started in the industry, there were about 60% of employers using some type of financial advisor to help them with their retirement program. And they were traditional brokers, and brokers got compensated based upon what funds they had in the plan and by the providers. And there were probably about 329,000 brokers out there running around selling retirement programs. When the 408(b)(2) regs came to fruition and the lawsuits really started to heat up, what we saw is that major firms like UBS, like Payne Webber, Payne Webber is part of UBS, but like JP Morgan started to say, we're not going to take this liability on by running and managing these retirement programs. And we saw the market move from a broker to a consultant to a co-fiduciary status. And we saw the number of people that were providing these services dwindled down to about 5,000 consultants, co-fiduciaries that are handling plans. And about 80% now of employers 80+% use some type of co-fiduciary on their retirement program. I think it's going to be the same in the healthcare space. We have brokers today. We have some that have moved into a consulting role, which is fabulous. And I think those consultants will move into a co-fiduciary role as they start to evaluate the risk, understand how to mitigate it, to take those liabilities on. And again, we're in an evolving market. So I think it's a rinse and repeat of what we saw in the retirement space. Smaller percentage of people handling a larger percentage of employers.
Interesting. Chris, are you in a position, I know you're driving, but do you have thoughts? Chris Deacon.
Yeah, I am on. I am less convinced that the consultants are going to enter into a fiduciary role. And I think one of the distinctions here is in the financial services industry, there's exercise over plan assets. And in this case, the consultants, at least the ones that sort of I'm familiar with, they're not exercising control over plan assets. And so I think there's a distinction there. I do think that in the future, there's going to have to be a much more clear delineation as to where the buck stops. I think with, black and white, who's a fiduciary over what, and I'm hopeful that these cases are going to flesh that out, because regardless of the outcome, we will have some clarity, I hope, because right now the true enemy is not knowing where the buck stops and people pointing fingers at other people. So yeah, I'm less bullish on consultants becoming fiduciaries, unless they're exercising actual control over those assets. But I think we're going to have some clarity in the next few years about, who's actually ultimately responsible for, exercising fiduciary obligations over the plan assets.
Chris,
Thanks, Chris. Steve, before you jump in, let me just give Darren a chance to share his thoughts, and then we'll kind of do some discussion and questions.
Let's
do Steve's question first, and then I can weigh in my thoughts.
Okay, go ahead, Steve.
Oh, I mean, that's a great point in terms of me being pretty much a neophyte to this whole thing, Chris. But if I could dwell on it just for a moment, I think I understand that a retirement advisor has influence and control impacts assets. I agree. If we broaden the definition of assets and just say in terms of comparing a health plan advisor to a retirement advisor over the funds that employees are investing in those respective programs, products, could you make the case that a health plan advisor has as much influence on the value that investment on the part of an employee produces in the healthcare arena as they do in the retirement arena?
So in my opinion, this is the messiness of, with money, right, and retirement funds. it's very straightforward, right? It's assets, and the assets are dollars, right?
Agreed,
They are
agreed.
financial, right? When it comes to a health plan, right? I mean, there's a certain amount of exercising prudence over, okay, where am I going to put my members' contributions? What bank account is it going to be interest bearing? Is it not? Like, there's those questions, and then there's questions like, do I go with independent TPA or carve out PBM? Or the advice becomes much more fluid and subject to the gray, which is why I think I don't see anybody running to want to be a fiduciary in the consulting space, nor do I think that it would necessarily be a good thing for employers, because then we're going to stay in that gray space. We're not going to have a buck stops here, right? That's in my opinion.
And I would just say, Chris, I mean, the traditional fiduciary in the retirement space is the 321 or the 338, and it does have to do with the investment piece. However, I have seen some cases in the retirement space where a co-fiduciary, a consultant that is signed on as a co-fiduciary, is held liable for the decision process being made, not necessarily for the asset, where the assets are being placed. So I think, to your point, that no one's running to do it. No one ran to do it in the retirement space either. It kind of it became something that could differentiate the market. And again, that's why a lot of the larger firms said, we don't want anything to do with this because the liability associated with it is too great. But I think it's going to be something that will evolve. And I do think that the courts will determine what the fiduciary kind of word means to a certain degree. And so I agree and disagree with you a little bit, but I understand what you're saying.
Darren, what are your thoughts?
I mean, I agree that it's messy. I agree that it's a lot less clear. I also think one thing that shouldn't get lost is that discretion over assets and how assets are used is not the only trigger for fiduciary liability. Holding yourself out as a trusted advisor is also well known to be a trigger for fiduciary liability. And that might actually be the more definitive way of connecting the two. And you saw this with the Florida lawsuit. The district court judge said that they agreed. She agreed with the fact that Gallagher was a fiduciary to the school system based on how they held themselves out as experts that the school board could rely on. So I don't think it's out of the question. Now, I think that case sort of had some particulars in how Florida law was that probably influenced that decision. I don't really know much more beyond that. I don't think that consultants by and large are going to run for fiduciary obligations. I will say the first consulting firm that I worked for, it agreed to be a fiduciary in the contract. So there is at least one that I know of. I know that there are a few PBMs that this is part of their, you could look at it cynically and say it's part of their marketing. I've talked to a few representatives of their firms, and they're very excited about being co-fiduciaries to their plan sponsor clients because they think it's a really important part of solving the alignment problem. I think at the end of the day, it is an opportunity for smaller boutique consulting firms to seize on the compensation disclosures and say, I think it's the second thing that has to be on those things. Are you a fiduciary to your client? Right. Most people are going to check the box no. I think that that's how the vast majority of consultants will check that box. And I understand that it is an increase in liability if you check yes. And there's a whole lot beneath that even people who check yes may not understand or fully appreciate. But it is an opportunity. I think it could be an opportunity. Whether or not the market, forces consultants to do that as trusted advisors to their clients or not. That's kind of where I am at with it on this point.
So I'm going to just open it up and see if any of the consultants, Scott, any thoughts you have on this or any of the other consultants?
Yeah, one of the thoughts that I've had around this, because I tend to agree with the perspective that Chris presented, because technically a consultant, if their statement of work is written appropriately by the plan sponsor, they're not touching plan assets per se, within the health plan environment. But one of the bigger issues that we are observing is this concept of, these self-insured plan sponsors, they all want their data. But the reality is most plan sponsors are clueless on what data is, what level of detail they should be requesting, and then how are they going to warehouse and secure that data. And there's a number of brokers and consulting firms that are stepping up and saying, well, hey, we'll warehouse that for you. At that point in time, I believe then that organization just stepped over the role and expanded their scope from consultant broker to, providing data warehouse and then potentially analytic services. Okay, there, I think they just stepped over the line as a service provider and expanded that scope and exposed them to that fiduciary exposure. Because that data is the property of the plan sponsor, at least in my opinion, and holding somebody else's property, you're in a ministerial capacity to that plan sponsor, and therefore as their servant, then you are basically held liable, whether that's as a fiduciary or through contract law. You could debate that as well, but, I tend to lean more toward it's a greater value to the plan sponsor to fall to contract law than try to pursue these people as fiduciaries, because the courts are inconsistent. And then when they have basically ruled, every time they rule, if you go to Massachusetts laborers, you look at PBM stuff where they've gone after these organizations as fiduciaries, the courts have basically said, no, they're not fiduciaries. And shame on you, the plan sponsor, for getting yourself into a contract that you can't enforce.
Can I piggyback up that?
Sure.
One of my concerns is I think we're grasping and wanting, because we know that employers have been, whether it's taken advantage of or they've had their eyes closed and the last 20 years or 30 years have happened. And so we're sort of grasping and we're like, oh yes, we want to make you a fiduciary, and we're sort of approaching it with a fiduciary designation is an inherently beneficial thing to the industry. And I would pause and say, we don't want to erode the value of that fiduciary relationship by, sort of allowing, and with Darren saying some are using it as sort of a marketing ploy. I've seen that, and it makes me very nervous because, I don't want to erode the sanctity with which that relationship should be held. And to your point, Scott, I think that courts are recognizing that. And that's why I say, at the end of the day, the clarity is going to be key. Clarity is the win, in my opinion here.
Right. Good point. Other thoughts? I've got another direction I want to take this, but I want to see if there's other comments or thoughts on this topic.
Well, this is a classic case of the federal government getting involved in a new area of regulation, and we're all sitting there speculating about how this is going to shake out, and it's going to play out through the courts, and 10, 15 years from now we'll know a lot more certainly what's going on. But this creates a lot of opportunities, but it also opens up a lot of potential liabilities for a lot of people. So it's typical stuff.
Daryl, this is Heidi.
Heidi?
A couple of things, and Christin, Scott, and Martin, I agree with what you're saying, but as we talk about some of the data side of things and what we're seeing even in the 4 bills that just passed the House, one of the things that we're observing is a real focus back on some ERISA terms, and some of those ERISA terms are reasonability. And so even though ERISA already states what, trying to define what reasonability is, but now it's being brought into some of these new pieces of legislation in regards to data and data handling. And what does that look like, not only in and they're using the term reasonable to include the ability to audit the claims, and what does that look like in the handling of that, and then bringing it into even the business associate language. So I think that we're foolish as an industry not to start framing where we define those lines, because if we don't define them, somebody else is going to define them for us. And so how do we define those lines, keeping I think, align with the integrity of what fiduciary and what fiduciary means. But I also I also think that we as an industry need to set some of those guidelines to be able to guide the industry appropriately in that as well.
Yeah, because from my opinion and viewpoint, the data set should be the entire universe of all data
Yeah.
elements and all adjudication elements down to 10 to 15 to 20 ICD-9 codes
Yeah,
and diagnosis codes, right?
Yeah.
Everything. Now, I also would add that data is not Deer Walk. It's not
No.
Cotiviti. You know, their universe of data that they need to, create these really nice dashboards is like this. The data environment we work in is like this.
it's huge. Yep.
Yeah, like we take snapshots of our managed care clients' claim systems to a point where we could put them back up to business if they ever crashed.
Right.
So that your point, and the reason I say that, Heidi, is that your point is really well taken, that I don't know that we want legislators defining what data is. I think we want the market to define it.
Right.
And the plan sponsors demand what they expect. And otherwise, I think what's going to happen is you're going to have lobbying forces limit the amount of data and the data that you can get access to.
Right. And Scott, adding to that, I think that as we start talking about, using responsible AI and machine learning, et cetera, that we need to lead the charge from, and Chris, you've done that obviously in the transparency side of things, but I think that we need to be more active and engaged in those dialogues and influencing that from a policy level.
Thanks, everybody. I would like to ask the question, and it could be that I just didn't know, but when I was with Jamie, the comment came up that many employers think that by having omissions insurance, that they're covered for the fiduciary responsibilities they hold with the health plan. And that's just not the case. So I'd be very interested to know how common, and I was talking to just yesterday, Jonny, saying that in his case, that's one of the very first things he recommends any of his self-funded employers doing is get fiduciary liability insurance. How common is it for a ERISA plan that becomes self-funded to add that fiduciary liability insurance? And is that something we should be making a bigger deal of so that employers realize that they should be covering themselves because they are fiduciaries in many cases, or at least the committee that's being given oversight is. So share with me your thoughts, Jamie, Darren, Chris, Scott, anybody.
We've seen a little bit of a disconnect between the committee and who's purchasing the insurance for the committee. Even in the retirement space, when you talk about fiduciary insurance, some of the committee members say, do we have that? Did we get that? So when we talk to employers about fiduciary insurance on their healthcare plan, we get the same kind of deer in a headlight look. Do we have that? Isn't that part of this, whatever policy they rattle off? And in the retirement space, the fiduciary and liability insurance rates are going up because of the litigation and the cost of settlement and litigation with these cases has continued to go up. So I don't think a lot of employers have it on their radar. They, in my opinion, they definitely should, but they should also be aware that when the litigation hits the healthcare space, which it will, just because it's going to be part of the disruption and the transformation, it may be very costly to purchase.
If you can.
A question, I guess, I believe, Jamie, you said you coming from the retirement space. Are a lot of employers assuming that their fidelity bond, which is typically purchased when they get their 401k, it's a requirement unless I'm mistaken. I think that a lot of people are thinking that that is the extent of what they need for their health plan and that they're covered as fiduciaries, which it's certainly a step, but it's not the full coverage. Is that your experience?
It is, but because the liability associated with running in the retirement program has been more employers have been more aware of it. Fiduciary insurance has been more of a topic, but definitely in the healthcare space that we haven't found one employer that said, oh yeah, we have that. We're still finding that 50 to 60% of the retirement employers have fiduciary insurance. And to your point, they think they're covered under other policies, Fidelity Bond being one of them.
Anybody else have input on that aspect?
I just
I
wanna
think I'm
throw
just
out there-
glad I'm in the space I'm in and not having to deal with this with group.
And someone was mentioning that rates are going up. From what I remember with my clients, as a percentage of the spend for their health plan as a whole, we're talking not even like pennies on the dollar, we're talking hay pennies on the dollar. And so it's really there's not very many barriers as far as cost to protect them on the fiduciary liability. It really just makes a lot of sense.
I'm going to go back to Steve's comment, because one of the questions that I asked Jamie when we were together a couple of weeks ago was, well, if employer just does an ICRA, then they pretty much don't have any fiduciary responsibility. And the comment was, well, if they don't do anything in terms of directing that employee as to where to spend the money, that might be true. But in most cases, employers are involved in saying, okay, here's some things that are coming along with that ICRA, and that puts them in a fiduciary responsibility. So maybe, Jamie, you could kind of respond to Steve's comment. If you use an ICRA, what are your scope of fiduciary responsibilities?
Well, I think we talked about this in the training program, and Julie, who's an ERISA attorney deep into this stuff, kind of agreed that most employers will still have some liability associated with that. But it all depends on, how close they are to that. So I think it's dependent on the employer.
Yeah, and we make sure they have all the ICRA reporting for sure. I know it's not the fiduciary side, but we cross all the T's and dot all the I's for them, which is not nearly as much as what everybody here is talking about. But I guess we'll see where that goes.
Well, and there's no question that an ICRA, basically says employers are just simply giving employees money and letting them choose where to spend it. So in some respects, you would think, wow, what responsibility would an employer have fiduciarily if they're just simply saying, here's my money, go spend it? But like you said, I think we'll find in time.
Yeah. So Daryl, I think fundamentally though, I think we have to kind of step back and say, just like an investment policy statement of the retirement plan, we have to start with some of those foundational things within the health and welfare side to start saying, what is the policy of the employer? What are they going to look at? And to kind of the comment that we made before about data, how much is data going to play into that, whether that's cost accountability, quality scoring, all of those other things. What does that look like? Because that's going to be, especially on a self-funded plan where you have a plan document that prevails as far as the governance oversight of that self-funded plan, a policy statement can't be in conflict with that, or you've got a fiduciary risk, right? Just in the inconsistency of that. So I think there's some fundamental things foundationally that we need to start thinking about and assisting clients in developing some of those policy statements.
I would agree, Heidi. I don't think that being a fiduciary should be a scary burden for an employer, but right this second, because they haven't thought about it and how they're going to manage it, it is. It's overwhelming. But the reality is that ERISA is based upon process. It doesn't mean that you are making the right decision or the wrong decision. It means that you're acting in the best interest of the participants to provide a benefit at a reasonable price, and that you're doing it with an unbiased, conflict-free environment, and that it's a repeatable process. And I think that's what I continue to tell employers is, start with baby steps. Let's get a committee together. You already probably have a committee, but this committee is actually your fiduciary committee for your healthcare plan. Now you just need to start to act accordingly. You may already be doing a lot of the things that are required as an employer from a fiduciary standpoint, but you're just not doing it within a process. And I think, Heidi, to your point, is to start to establish that framework for them so that they can build upon it. And so that they're able to have established a process, that they can adhere to that process, and that they can document that process. So if they're asked by the Department of Labor or they have to defend themselves, they can say, these are why we made the decisions we made. And if you have ever sat on one of the Department of Labor's webinars, which I have to tell you can be very painful because they're quite dry. They talk about facts and circumstances. They talk about that this is a process that's evolving. It's not a set it and forget it. It's something that you constantly have to be monitoring and reviewing, because new information and new systems are constantly coming up. And so if we can start the groundwork and then build the framework, I think you can continue to build off of that. And it shouldn't be a scary process. The opportunity for impact, positive impact in doing this, I think could be massive. It's just actually starting it. That's the scary thing, I think.
Good
So
comment.
I would pose a question to this group, because what we're hearing as we have inquired, because we have not received any guidance, obviously, on what CAA fiduciary rules are, and the actual sense that we're getting is that they're not going to issue necessarily guidance right now on that framework. Is anybody hearing anything differently than that?
Well, I think it runs counter to the intent of ERISA to give guidance on that type of stuff, unless I'm misunderstanding your question. I mean, I think
Yeah, but because they've already issued some guidance, obviously, on the retirement side, what would, do they anticipate giving anything here, right?
Everything that we've heard, they continue to point us back to everything that we've seen and heard, they continue to point us back to what was established in the retirement space.
Yeah.
And so I think that's a great place to start. I do think that there are differences between the healthcare and the retirement industry, obviously, but I think the process could be interpreted very similar. And I think that's what they continue to point us back to. You go back and look up what we said and the guidance that we gave on that. And then remember, the courts are really, I mean, we get these regulations, but the courts are really deciding how we should be interpreting them. And so I think you can go back to some of the cases and determine, like, who is being called a functional fiduciary and how would that apply to something in the healthcare space. I think that's a good starting point.
Well, and can I ask the group in the last 10 minutes to think about, not on a defensive level, how do we keep from being sued, but how can the CAA regulations and rules support this effort of getting employers to start being on the offense and actually using this impetus to begin defining their business objectives and begin to measuring and monitoring those, and to expect that the healthcare system be aligned with them, not only their internal teams, but their consultants. I'd love to hear people's thoughts on that.
Well, I would assume when they find, for instance, they find out their consultant is referred them to a PBM and is reaping $2 per script, and they've got 10,000 scripts a month they're collecting that $2 on, they're going to get a little upset with them. They were completely unaware of that relationship. They just thought they were working with the best PBM they possibly could be working with. And, the more information they've got, the more rational decisions they can make, the more questions they can ask. But they've been paying they've been paying a lot of commissions to a lot of entities they were totally unaware of.
Right.
They're totally in the dark about that.
But Martin, to your point, it's like I wonder how many of these disclosures actually have that information contained on there. And I strongly suspect that there's fewer than there should be, far fewer. So I wonder if part of the answer to Daryl's question, spin on what you just said, is the proactivity to go and to say, I want full disclosure of every single bit of compensation you're getting from my PBM. And I'm going to go also ask my PBM separately if they will disclose that information to me. And it's like, are they actually going to get that information? I think that's like the jury's completely out on that. I think a lot of employers will continue to be frustrated by the lack of clarity that they get from both sides of that equation. But I think that asking strongly is part of the process that needs to be followed to be a
part of this, but I've read the requirements under the CAA as far as disclosures, and I was under the impression that everybody that's deriving some income from a book of business has got to disclose that. The broker's got to disclose that. Am I incorrect in that?
You're not incorrect, but what I've heard from other brokers at more of the national brands, and not all of national brands certainly, but some of them, is that they have found a loophole, at least for now, where a lot of this extra, let's call it more hidden commissions, get paid to the house at the agency level, not at the broker level, and then the house will then redistribute internally as like a bonus on your compensation. But they're basically saying this isn't commission to you, Mr. or Mrs. Broker. This is commission to the house, and therefore I don't have to disclose it because it wasn't commission paid to me directly as your agent. And it's it even like feels filthy coming out of my mouth right now, but that's really what I've even heard it is happening. It's not that it's speculated that it's happening, it is happening. So that's anyway, that's kind of how some firms are dealing with it.
Any and all PBM coalitions, once that floats to the surface, it's going to get really ugly really quick.
Yeah, this is Terry Killey. I'm Scott's partner. I'm the PBM guy with us. I mean, what you just described, where the operating company has a fee that's not directly related to a client's, that has existed since I started in the industry in '94. Very standard, because in the old days it gave the front line person safe harbor to say, we're not getting any money in your account. The PBM's not paying us anything on it. But meanwhile, and again, I it's really not appropriate for me to get into the amount of money, but it's massive.
Yeah.
To be on the bid list, the quote bid list. There's all sorts of stuff that I ran a PBM for a very long time. The consultant groups, I'm talking large ones, the ones that everybody knows, big ones, would come in and say, we're going to review your operations, and if it looks good, you'll be on our bid list, and that review will cost you 7+ figures.
Yeah, that's exactly what happened in the retirement space, guys. It's such a rinse and repeat. It's just funny that everybody thinks that it's never going to come out. It does. It comes out. It's ugly. As Scott said, it's going to get ugly. But employers, unfortunately, at this moment, don't even know the questions to ask to start to be strong and empowered. I've read a lot of these disclosures from everybody, from the boutique firms to the big firms, and they are dancing around the indirect compensation like you would not believe. And there's a lot of language in there that says, the House receives this. We can't determine what percent, what amount goes towards plans. But if you read the CAA and what's required of that, they have to make a reasonable estimate of what they are receiving. But employers, again, don't know to ask those questions. So but it's exactly what happened in the retirement space.
Well, part of the problem is that the traditional employer plan sponsor broker relationship has been driven by relational values, not competency values. Right. And the reality is there's actually very few brokers that quite honestly know their ass from a hole in the ground. They're product pushers. They're not consultants, and they're not technicians. And, and I'm coming up on 40 years, so I can make those statements, right? The other part of it is that the employers themselves are clueless. Some of the things we run into, like we just did a project for an organization that's in a coalition, and we showed them massive amounts of cost reduction through the RFP process where we validated the numbers using our methodology, and they're still emotionally attached to this coalition because they're really nice people. It's like, okay, you guys are getting screwed and we showed you, but yet you're going to violate your fiduciary obligation to your members by trying to make something that's broken fix. And the organization that's the service provider, they have no intent on fixing it.
Right.
So, we could go on and on with those types of examples.
Well, and my hope would be that this is a group of innovative consultants who are educating, consulting with, or directing employers that will rise to the top in helping employers get a clue. And I would love, maybe in just closing, Jamie and Chris, if you got anything you want to share, if you want to just do a quick little 30-second, here's how you can help consultants help their clients, I'd love for you to share that. Jamie, do you want to go first?
Well, the first thing that I think you can do to help your employers or help the whole marketplace is to talk about it. Exactly what we're doing. Talk about it to everybody and anybody that'll listen to you, because right now ignorance is bliss, and we need people to understand where they are today and where they need to be. Otherwise, the casualties are going to be very expensive. And I think the first thing to do is to just start talking about it. And then the second thing that I think they need to do is to start to establish processes. And the first step in doing that is setting up a fiduciary committee. So that would be another thing that I would say is top of the list.
Hey, Chris, are you still with us? Anything you want to add? I don't see her on the list. I think she had to drop off. Darren, anything you want to add?
She might be on my phone still. I'm not sure if that's her number, but could you restate the question?
Just what can you do to support this group of consultants in their efforts to try to rise to the top and help their clients so that they're not clueless and can get a clue?
Well, I would say that yeah, I echo what Jamie said. I mean, Jamie's such a great resource for this, and she's really informed a lot of my thinking on this, as has Chris and several others. I think consultants have a huge role in advancing this. I think that they can think about the ways that they can become consultative and useful in that way to employers in this. I just keep coming back to I think the comp disclosures are an absolutely amazing way to demonstrate value and to completely reset the conversation. I think that they're the biggest tool that smaller consulting firms have had to level the playing field from their competitors that we've seen in a long time, maybe ever. I mean, there's such an opportunity, and I think that consultants have to think of really smart ways to talk about how they serve their clients, why this is consistent with their business model, why they're able to be unique in a world where other firms cannot commit to the same types of levels of transparency. I think about that a lot. I think about that probably once a week. So anyway.
Thanks. Anybody else have any final comments you want to make?
One question I would ask Jamie is the CAA and public entities. We've talked about ERISA groups, but then, the CAA does also impact public entities through the Public Health Service Act. I'm kind of curious of your insight and thoughts on that.
It does. The CAA, the only thing that it doesn't do for that group is under ERISA, under the 408(b)(2), which is part of the compensation disclosure, being able to deem it reasonable. So that's the only difference. But what we've said to some municipalities that we've been dealing with is that you probably should look at your bylaws within your state or your municipality, but you probably have some requirements to your taxpayers that you are prudent with their dollars and are spending it in a reasonable way. And therefore you should be benchmarking and acting kind of the same as if you were an ERISA-based plan.
I saw a statistic from a longtime ERISA attorney that was around in its founding. It said that 70% of the states have adopted a similar standard to ERISA for prudence. I don't know which states didn't, but I just think it goes to show like how great of a framework that is, even for public entities.
I know we're at time, but I think Jamie and Darren, if you want to respond to this as well, kind of an adjunct question to Scott's, you know, what are you using then as a benchmark proxy for municipalities, right? If municipalities aren't responsible, what benchmark proxy are you using?
So right this second in your industry, in the healthcare industry, there's not a benchmarking service, a true benchmarking service like we have in the retirement space. But the first thing that I tell an employer, regardless if they're ERISA or not, is that in order to deem something reasonable, you actually have to be able to tie a fee to a service. So if you can't tie that fee to a service, then that's unreasonable right off the bat. And then if you can tie it to a service, then you should be looking at the outcomes. But we already know of some groups, and we've been doing it as well, that are starting to benchmark reasonableness for fees from brokers. And it's not about the fee itself, it's about the services that they're providing for those fees and then the outcomes that they're producing. Does that help?
Yeah.
Well, I want to thank everybody. This is amazing conversation. I appreciate everybody. I'm happy to leave the conversation going if anybody wants to stay on, but I want to just say that I think one of the big signature issues that we need to remember and face is the fact that most private bankruptcies are because of medical debt. And most of those people had insurance through their employer. And there's a huge need to raise employers' awareness of what they're offering that's causing harm financially to their employees. That's the cause of the greatest number of bankruptcies in America. So that's kind of my thinking, is there's a lot of opportunity to improve here and to help people.
Hey, I've got a question.
Sure.
Daryl. So someone mentioned, you know, they don't know the right questions to ask, and there should be there's a checklist. Is there a list? Is there a list that anyone would have? I'm not a broker, and you know that, Daryl. But
right,
you know,
that represents the school district, right?
Yep.
Wisconsin.
Uh-huh.
So yeah, I think both. Well, I think Jamie, can you answer? I mean, you probably have that as a service, right? That you can help them. You have those resources available, as well as Chris probably does too.
Yeah, what kind of list are you looking for? There's a ton out there.
Well,
you know,
it was just, you know, I think you during the conversation you mentioned, you know, that they don't know the questions to ask, and you know, it's really about, you know, disclosure, knowing what, you know, all the hidden fees, all the things going on behind the scenes stuff with brokers.
yeah, I don't know if there's a list for compensation disclosures, but if you want to hit me up after, I'd be happy to go through what we would recommend they should be asking. But I think the broader comment was around employers don't even know what to ask any provider, you know, and I think Scott was talking about data. What kind of data should they get? The thing that scares me about this data is that employers are getting mass amounts of data, and they're not doing anything with it, and they're documenting a deficient plan, and that is scary to me. That they're
by not evaluating or doing anything with it. You mean the fact
exactly
that
taking no action.
Yeah, well, and one of the reasons that the carriers are pushing back on the releasing all their data, one is they know what will happen once somebody competent gets it. But the other piece, one of the reasons they're pushing back is that they realize that the plan sponsors and the brokers, average Joe broker, doesn't understand how to securely warehouse data. And they are fearful that they're going to have a major liability if there's a breach. So that's one of the reasons they're not just willy-nilly sending data out to everybody, is they realize that 98% of the marketplace has no idea how to even secure and warehouse the data.
I'd like to ask a quick question about the involvement of plaintiffs' attorneys in class action suits. That seems to be something that'll move this along. I assume it was what moved the retirement industry along. Is there any way to meaningfully extrapolate from what people know about what's being planned now, or what that would translate into a sort of a curve for us to anticipate when this is going to be hitting the market and so forth?
In other words, does it take 4 or 5 years for a class action lawsuit to appear, or can we expect them here in a few months?
So I don't know if you guys have heard the name Jerry Schlichter, but he's extremely successful, has recouped about $2 billion on the ERISA retirement side. And he is somebody that most employers are super afraid of. A couple of months ago, he posted on LinkedIn the ads that Daryl was talking about, saying, if you're an employee of Target, if you're an employee of State Farm, and you may have been damaged and are could receive a settlement for participating in their healthcare plan. Now, they interviewed him and asked him, why did they target these specific companies? And he came back and said, oh, we just heard some rumblings that perhaps the plans weren't operating appropriately, but we're not really sure. I know Jerry Schlichter. He doesn't have to be successful in these litigations. These employers will settle, and once they settle, whether they've done what he says they've done or not, I think it's going to be hard for him to prove certain things, but they'll settle. And that is what's going to start the momentum of Jerry saying, well, I can go after every employer because they'll settle. He doesn't have to know how to play the game. He knows the right way to he doesn't need to know everything about the healthcare market to play the game, is what I'm saying. So I think in the next couple of years, we're going to see a lot of litigation against employers. And I'd like to see employers stand up and have more litigation against the carriers and the others that have been kind of robbing them blind, as opposed to the employees suing the employers. But we'll see, I guess.
A quick follow-up question on the employer side, particularly HR. I guess I will call SHRM myself and try to find out, but how seriously is SHRM taking this? Are they preparing any kind of education conferences, that kind of thing, for all the HR people in the country?
Anybody know?
Okay.
I know Justin Leader has been very involved with SHRM, and I think SHRM is trying to get their head around this, but it's a lot. And, I know that's one thing that we did at the Think 360 conference, and we're doing in Houston. We're trying to do fiduciary education for employers around the healthcare plan and get them talking about it. But I'm still amazed at, when you talk to employers who have never heard of the CAA, and unfortunately, it's usually at least 7 out of 10, if not 8 out of 10 that you talk to that have never heard of it.
Yeah.
Yeah, that's pretty sad. I do want to mention before everybody jumps off that we do have another one of these Aspirational Healthcare Advisors meetings scheduled for the 28th of July. One of the national virtual direct primary care programs, Revive Health, is going to present. And then the next one, I don't know if Heidi's still with us.
She had to
jump off, but she's done some very creative things with Lee Lewis and is going to present to this group kind of as their first introduction to some of the creative things that they're doing for this group to use. I highly recommend you put the 11th of August on your schedule and don't miss that. I think
Are you going to send out invites to that?
Yeah, we send invites out after each one, kind of showing, giving the recording of the prior one, and then for the next one. So the next one will be July 28th. The one after that will be August 11th.
I just want to say Scott's my favorite guy in this whole group because he's wearing a Nebraska shirt.
Amy, thank
what?
you so much for being on. Darren, thanks for your input. Chris, I don't know if you're still on or not, but just thank you for being willing to be a part of this conversation. I found it to be very educational and very helpful. This is exactly what I was hoping we could kind of put our heads together and discuss.
Thanks.
Well,
Stefan.
thanks for having me. Yeah, it seems like you guys are rolling in the right direction and have some great members to help facilitate that. So appreciate the opportunity to be a part of it.
Thank you.
Thanks.
Thanks for convening us, Daryl.
All right,
Thanks,
take care.
guys.
Have a good weekend.
Bye.